Director of the Office of Electric, Gas, and Water at the New York State Department of Public Service. I've been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as it is also known, the Siting Board. I'd like to call this meeting of the Siting Board to order. And before we begin, I'd just like to say that it's very nice to be here in person, back here in the boardroom and with my fellow Siting Board colleagues. Before moving to the agenda, I'd like to introduce the alternates representing the permanent members of the Siting Board. Here in Albany, to my far right is Janet Joseph, alternate for Richard Kaufman, New York State Energy Research and Development Authority. To my immediate right is Dr. Elizabeth Lewis Michael, alternate for Dr. Howard A. Zucker, Department of Health. To my left is James McClymans, alternate for Basil Sagos, Department of Environmental Conservation. And in New York City is Vincent Ravishir, alternate for Eric Gertler, Acting Commissioner, New York State Department of Economic Development, and President and Chief Executive Officer Designate, Empire State Development. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you, Secretary Phillips. I will now turn to the first item for discussion today, which is case 18-F-0262, application of High Bridge Wind, LLC, for a certificate of environmental compatibility and public need pursuant to Article 10 to construct an approximately 100-megawatt wind-powered electric generating facility located in the town of Guilford, Chenango County, presented by Dakin Leacakes, Chief Administrative Law Judge, Department of Public Service. John Sipos, Deputy General Counsel, is available for questions. Judge Leacakes, please begin.
Thank you very much. Good morning, Chair Designee Mitchell and members of the Siting Board. Greetings from Western New York. Before you is a draft order that would deny the petition for rehearing filed on April 9th, 2021 by Guilford Coalition of Non-Participating Residents, GCNR. In its petition, GCNR seeks rehearing of the Siting Board's March 11th, 2021 order granting a certificate of environmental compatibility and public need with conditions to High Bridge to construct and operate a utility-scale wind energy facility with a capacity of 100.8 megawatts in the town of Guilford, Chenango County. GCNR makes numerous allegations about the order's alleged deficiencies, claiming the following: that the Siting Board incorrectly denied GCNR's motion for an extension of Article 10's 12-month decisional statutory time period in light of the COVID-19 pandemic, that the process in this case did not provide adequate public participation, that the parties did not properly follow the settlement guidelines, that the record was incomplete because the town of Guilford signed the settlement but did not provide testimony or a statement in support, that the Siting Board incorrectly affirmed the hearing examiner's ruling allocating intervenor funding and then denied GCNR's later request to reallocate additional funds from the town to GCNR, that the Siting Board incorrectly determined that High Bridge's service of a revised pre-construction noise impact analysis was proper, that the board incorrectly denied GCNR an opportunity to present evidence of potential impacts to property values, that an individualized impact assessment regarding shadow flicker should have been required for at least one flicker-sensitive resident, and that the board's analysis of shadow flicker impacts is deficient because the order does not require High Bridge to modify the project to accommodate the particular circumstances of two town residents, that the Siting Board's refusal to apply a World Health Organization conditional recommendation on noise limits was incorrect, that the record does not support the Siting Board's finding of sufficient mitigation to visual impacts and groundwater and well impacts, and similarly, that the Siting Board erroneously denied GCNR's proposed modifications to Certificate Condition 87 that relates to groundwater and wells, that the record does not support the board's findings on socioeconomic benefits because it does not contain a host community agreement or pilot agreement to substantiate such benefits, and finally, that the evidence in the record does not support the Siting Board's finding that the project is in the public interest. GCNR also requested a stay of any construction work and board or commission review of compliance filings pending a determination on its rehearing petition. To this last request, I note that Article 10 does not provide for any stay of a certificate holder's activities or responsibility to comply with the certificate's conditions, and no stay was required here. As for the petition, arguments on rehearing must do more than restate the same arguments that the Citing Board considered and rejected in the certificate order. As discussed in the draft order before you, GCNR's petition does not establish any error of law or fact to support its rehearing request. Instead, GCNR's arguments on each point were raised and fully briefed when made to the examiners and before the Citing Board, when the Citing Board considered and issued the March 2021 certificate order. Also, after reviewing the record, I note that it is complete and fully supports the Board's findings in that March order. As to GCNR's claims regarding the town's participation in the settlement, the guidelines do not require every party to a settlement to provide individual testimony or exhibit. A signature page is sufficient to indicate any one party's agreement with the proposed terms. Now, before I end, I would like to make one last note about the draft order's inclusion of a discussion regarding the issue of intervenor funding. GCNR attempts to support rehearing with emails it obtained through the Freedom of Information Law that were sent between employees of the governor's office and another completely unrelated renewable energy developer. GCNR did not provide these emails to be included in the evidentiary record, and even if they were obtained only after the Board's March order, they do not present any new circumstances for the purposes of rehearing. They are not relevant to this case at all. What is concerning here is that GCNR questions the examiner's objectivity and independence despite having no evidence that the examiners had any connection to the emails or were even aware that they existed. To make such an allegation without evidence is untenable. Yet GCNR tries to argue that it was withheld what it believes was sufficient intervenor funding based on an unsupported theory that the emails show some concerted effort to suppress funding amounts to opposition parties in Article 10 cases. Besides being completely unsubstantiated, GCNR's argument rests on a misunderstanding of Article 10 intervenor funding relative to the amount spent by any given awardee. In discussing this point, the draft order explains that while funding is made to help defray some of the costs of litigation, it was never intended to completely cover party expenses. This concludes my presentation, and we are available for any questions.
Thank you very much, Judge Leakakes. I'm persuaded that the denial on each of the petition's claim is proper and appropriate based on the record and the underlying facts, and I will be supporting the recommended denial. Let me now turn to my fellow board members for any comments or questions. Ms. Joseph?
No additional comments or questions.
Thank you. Dr. Lewis-Michael?
No comments or questions.
Thank you. Mr. McClymans?
No comments or questions.
Thank you. And Mr. Ravishir?
No comments or questions.
Thank you. With that, I'll now proceed to call for a vote. This is Tammy Mitchell, and my own vote is in favor of the recommendation to deny the petition for rehearing as just described. Ms. Joseph, how do you vote?
I vote yes.
Dr. Lewis-Michael?
In favor.
Mr. McClymans?
In favor.
And Mr. Ravishir?
In favor.
Thank you. The order is approved and the recommendation is adopted. We will now move on to the second item for discussion, Case 16-F-0328, application of the Number 3 Wind LLC for a certificate of environmental compatibility and public need pursuant to Article 10 for construction of a wind project located in Lewis County, presented by Heather Benke, Assistant Counsel, Department of Public Service. John Sipos, Deputy Counsel, and Brian Osius, Managing Attorney, are available for questions. Ms. Benke, please begin.
Good morning, Chair Designee Mitchell and members of the Board. Before you today is an order granting a petition for amendment of the Board's November 12, 2019 order granting a certificate of environmental compatibility and public need with conditions to Number 3 Wind LLC. The certificate authorized Number 3 Wind to construct and operate up to a 105.8 megawatt wind-powered electric generating facility consisting of up to 31 utility-scale wind turbines and associated facilities in the towns of Lowville and Harrisburg in Lewis County. On March 11, 2021, the Siting Board granted a petition for amendment which authorized Number 3 Wind to install fewer turbines, 29 instead of 31, but to increase the maximum turbine blade tip height for up to 24 turbines from 586 feet up to 591 feet. On May 24, 2021, Number 3 Wind filed a subsequent petition for amendment seeking an amendment of Condition 38 of the certificate, which requires Number 3 Wind to file Federal Aviation Administration permits and required approval documentation prior to commencing construction. Specifically, Number 3 Wind seeks to have language in Condition 38A and C changed to allow the required FAA approvals to be filed prior to turbine erection instead of prior to construction. According to Number 3 Wind, the changes are necessary because the taller turbines approved in the March 11th Amendment Order require the federal agencies to confirm that their prior approval for the certificated facility with respect to airspace remains applicable to the slightly taller turbines approved in the Amendment Order. In its petition, Number 3 Wind explained that Fort Drum technical staff confirmed that the minor increase in height was acceptable, but unexpected administrative delays in the federal agency review of the final turbine heights necessitates the change to the wording of Condition 38 in order for Number 3 Wind to meet its construction schedule for the project's expected in-service date of October 2022. The order before you recommends approval of the amendment. Approving the requested change in language in Certificate Condition 38A and C merely clarifies that the new turbine design that was approved in the March 11th Amendment Order may not be installed without FAA approval. If the order is approved, all of the certificate conditions will remain applicable, including the requirement to have a decommissioning plan approved prior to commencing construction. Number 3 Wind is required to post letters of credit to cover the cost of any decommissioning related to the removal of the foundations and site restoration in the event the FAA does not approve the turbines or makes additional changes to the project layout. Accordingly, the order before you approves the petition for amendment of the certificate. That concludes my presentation, and we are available for any questions you may have.
Thank you, Ms. Benke. I find that the proposed amendment is substantially a clarification to Certificate Conditions 38A and C and would not have any adverse environmental impacts. I will be voting in favor of the recommendation. I'll now turn to my fellow board members for any comments or questions. Ms. Joseph.
No comments or questions.
Thank you. Dr. Lewis Michael.
No comments or questions.
Thank you. Mr. McClymans.
No comments or questions.
Thank you. Mr. Ravishir.
I have no comments or questions.
Thank you. I will now call for a vote. This is Tammy Mitchell, and my own vote is in favor of the recommendation as described. Ms. Joseph, how do you vote?
In favor of the recommendation.
Thank you. Dr. Lewis Michael?
In favor.
Thank you. Mr. McClymans?
In favor.
Thank you. And Mr. Ravishir?
I vote in favor.
Thank you. The order is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
There's nothing further today.
Thank you, Secretary Phillips. With that, we are adjourned.